When do we want to start?
Hello, Dr. Chirag.
Everyone, Payal madam, may I start?
Yes, go ahead, Padma.
Good morning, Dr. Payal. Pleasure meeting.
Same here.
Bhumika, proceed further.
Good morning, everyone present here. On this beautiful morning, I, Bhumika Sehgal, student at Rashtrasan Tukroji Maharaj, Nagpur University's Postgraduate Teaching Department of Law, Nagpur, is pleased to welcome each and every one of you to a brainstorming webinar on evolution of hybrid ADR mechanism. We would like to express our heartfelt thanks to this esteemed institution for organizing this webinar. To further enlighten us on the evolution of hybrid ADR mechanisms, we have invited Mr. Chirag Balian. I now invite Professor Payal ma'am, HOD and Assistant Professor at Rashtrasan Tukroji Maharaj Nagpur University's Postgraduate Teaching Department of Law Nagpur to kindly take over the virtual dais and welcome our guest for the day, Mr. Chirag Balian.
Very good morning, Dr. Chirag, and good morning, all the dear participants. On behalf of Postgraduate Teaching Department of Law, I extend my heartfelt welcome to all of you for this national webinar on evolution of hybrid ADR mechanism in India and of course globally. Considering the nature of dispute which we are facing now in this contemporary era, and then of course the pendency of litigation and then the lack of infrastructure, we think that these kind of hybrid ADR mechanism will really provide a substantial and sustainable solution when it comes to redressal of the disputes. And for knowing further on this particular area, we are really thankful to Dr. Chirag Balian sir for gracefully accepting our invitation and gave his consent to enlighten all the participants on this particular very relevant, and I would say rather the need of the hour topic, that is evolution of hybrid ADR mechanism. So we welcome you, sir, and looking forward for your lecture. Thank you.
Should I begin?
Now, I would like to introduce our today's esteemed resource person, Mr. Chirag Balian. Sir is currently working as an assistant professor at MNLU Mumbai. Sir has an educational qualification of BSL, LLM, LLB, LLM. Sir, Mr. Balian has been a resource person in plethora of certificate courses, seminars, webinars, roundtables, and workshops. Sir has been a course director for training program on mediation and negotiation from 2015 to 2017. Sir has published various books and research papers nationally and internationally, and have also been a part of various research projects like Research Advisor Report on Virtual Hearings in India, published by Center for Arbitration and Research, MNLU Mumbai 2020, Research Advisor comments on draft Code of Conduct for Adjudication in ISDS submitted to UNICETRAL and ICSID 2020. I now request Mr. Chirag Balyan to take over the dais and further enlighten us on the evolution of hybrid ADR mechanism. Over to you, sir.
Thank you, Bhumika, for the kind introduction, and thank you so much, Dr. Payal, for the kind invitation, and Professor Padma for painstakingly listening with me in organizing this webinar. A very good morning to each one of you. As rightly pointed out by Dr. Payal, one of the contemporary issues, ADR is still developing in India, and we are already talking about the variation of ADR in terms of hybrid ADR. So I hope all the participants here today will benefit from this session. Thank you so much again for giving me this opportunity. Before I start my session, as a teacher who has been conducting these online sessions since quite a few years now, 2020 to 23, I would request each one of you to open your camera as far as practicable. It should be an interactive session. You should be, as I understand, most of you are students of post-graduation, so you have elementary knowledge of arbitration and mediation. I would request you to keep your cameras open. Make it as interactive as possible. Stop me anywhere. Ask me questions at any point of time. Do not hesitate. The more you interact, the more energy I'll get, and I believe more fruitful the session will be. So it should be the mutual symbiosis of you and I in this knowledge sharing session. So let me begin by sharing my screen. All of you can see my screen.
Yes, sir, it is.
Thank you so much. I will start straight away with the question, what is hybrid ADR? And I'm not going to what is ADR. I will start with why do we need hybrid ADR? See, the way we advertised arbitration and mediation as alternatives to court, it seemed like that they are flawless. They are the perfect systems we could ever have. This is not the truth. Arbitration per se, though is described as ADR, is very costly. It is very time consuming. Though now after 2019, we have statutory time limits that within 12 months an arbitration must be completed. But we have documented cases wherein arbitrations have taken 5 to 8 years, even 10 years. So if it is taking 10 years, how good that arbitration is. And we all know that we do not get the court infrastructure in arbitration. We have to get our own infrastructure, pay for it, pay to the institution. So it's costly. We have to pay the arbitrator. We don't have to pay a judge. Judge salary is paid by the government, though it's our money as taxpayers, but it is by the government, but arbitrator we have to pay. So it's very costly. On the other side, when we think about mediation, mediation is an excellent phenomena, but the process is voluntary, which means party can withdraw anytime. If they don't want to come to settlement, they will never come to settlement. And even if you come at settlement, there is no guarantee that other party will comply with it. You can always backtrack. You can always say, I don't want to follow what we decided. I've changed my mind. So hybrid ADR as mechanisms have evolved to undo these disadvantages of arbitration and mediation. Can we club arbitration and mediation in such a way that we get best of both the worlds? We can have the certainty of arbitration in mediation and we can have cost effectiveness and time consuming of less time consumption of mediation in arbitration. This is the fundamental reason why in 1970s Sam Kegel introduced the idea of MEDAR. There was a very big strike relating to public sector services, public utility services by the nurses in San Francisco. Entire public system, buses, hospitals, schools, everything came at a halt. The idea was how to tell nurses, how to tell the workers that they have to do the work, they have to resume these public services. These are essential services. But they were on strike after complying with all the requirements. Sam Kegel intervened and introduced the idea of med arbitration, which helped San Francisco in that time in resolving that strike issue. So that is the first time when the term med-arb was coined. As the term hybrid indicate, I believe most of you are from Nagpur. Nagpur is known for hybrid. It is known for oranges. So we have oranges, we have Mosambis, and then there is this hybrid quinoa. So in terms of geography, Nagpur is no stranger to what hybrid is. Hybrid is mixture of two things, right? When you intertwine two processes, that becomes hybrid. You can use mediation with arbitration, you can use arbitration with mediation, you can use negotiation with arbitration. It is hybrid ADR. If it would not have been ADR, you can use arbitration with litigation, you can use mediation with litigation. Like we have in the Commercial Courts Act, there is compulsory mediation before litigation. So that is also hybrid dispute resolution process, but not hybrid alternative dispute resolution process. And that's why we will keep court adjudication, wherein hybrid is there, out of the scope of this lecture. There are so many hybrids which are existing in the court adjudication process. So we will only confine to the popular ADRs like arbitration, mediation, conciliation, and negotiation. We will look at their hybrids in today's session. If there are no questions on what is hybrid ADR and what Sam Kegel did at the San Francisco nurses strike, I would like to move to the second slide. Fine? Sure. Now, look at the big list of the hybrid ADR. Because once we start drawing the combinations, we can have n number of combinations, right? I don't know how many of you have heard about even 20% of these combinations. They are not very popular in India, but they are happening in India. Mass scale, they are primarily used in United States, United Kingdom, Australia, and all the common law countries wherein there is huge workload of the court. So what is MEDAB? MEDAB is, to begin with, there is a mediation between two parties. But there comes an impasse in the mediation. Both the parties are not able to make a headway. They are stagnant on their positions. Now, what is to be done? There are some techniques in mediation to bring an impasse. But if the parties are headstrong that they don't want to continue with this mediation, what should be done? Should we take it to the court? That frustrates the entire purpose. If you had to go to the court at first instance, why you started with the mediation? So we are saying, okay, let's try arbitration. If there's an impasse, let the same mediator serve as an arbitrator and let him now pass the binding decision. So what started as an optional mechanism, as a voluntary mechanism, mediation is a voluntary mechanism, right? So what started as a voluntary mechanism, because of the impasse of the party, became a binding mechanism because arbitration is a binding mechanism. So now dispute will be resolved, but it will be resolved by the coercive machinery of arbitration, not by the free participation of the parties. This is Med-R. In India, we see a distinction between mediation and conciliation. And therefore, another type of hybrid ADR could be concilio-R, conciliation and arbitration. I don't want to get into the distinction of what mediation is, what conciliation is. I believe as postgraduate student, you understand that. But whenever conciliation is happening under Arbitration and Conciliation Act of 1996, Part 3 of the Arbitration and Conciliation Act, you can also combine arbitration. Because while conciliator may give opinion, may give suggestion, may influence the decision making of the parties, still the parties may not come to the consensus, and that is why there might be a need of arbitration. This is concilio arbitration. Then ARB, Med, ARB. Med, ARB starts with mediation. ARB, Med, the first process is arbitration. It means you had an arbitration agreement. Pursuant to the arbitration agreement, you started arbitration. It is very much similar to Section 89, reference by court to mediation or reference by court to arbitration. What does court do when it refers the parties to mediation under Section 89 of the Code of Civil Procedure? It sees that there is an element of settlement in the dispute. It sees that this is a dispute which can be amicably settled. So this is what ARB Med ARB means. Arbitrators see that there is an element of settlement in this dispute. We need not give a final verdict, a binding verdict. If the parties can themselves resolve it, let them resolve it. So arbitration will refer the matter to mediation. He will help the parties in arriving at a settlement. And if the settlement is arrived, again arbitration process will commence and the settlement agreement will be passed as an arbitral award. Many legal counsels, general counsels of the corporates I talk to, they say we prefer ARB Med ARB rather than mediation or rather than arbitration. Why? Because if they just do mediation, the decision of the mediation is not binding. The decision of mediator is not binding. Because of ARB Med ARB, now the settlement agreement between the parties pursuant to the arbitration, pursuant to the mediation, will be passed as an arbitral award. Settlement agreement will be passed as an arbitral award. It means the mediated settlement agreement has a binding value. It can be enforced in the court of law if one party refuses to follow it. So ARB Med ARB, you have an arbitration agreement, start with arbitration, refer the parties to mediation, and then come back to arbitration in terms of formalizing the settlement agreement. I use the word formalizing the settlement agreement. Co-Med ARB is again another phenomena. It's a variation of Med ARB, and I will tell you in the later slide why it is a variation and how this variation is important. In co-Med ARB, there would be two mediators. There will be two mediators. The role of one, or we can say there would be two neutrals. The role of one neutral is to act as a mediator and the role of other neutral is to act as an arbitrator. So both of them will conduct the mediation, but the one who is supposed to play the role of arbitrator will not attend the caucus, will not attend the private session. In case mediation is unsuccessful, the person who didn't attended the caucus, the person who didn't attended the private session will hold the arbitration. What is the objective? The objective is, if as a mediator, I receive the confidential information of the parties, then I can use that confidential information of the parties in arbitration process. This violates values of both arbitration as well as mediation. So the question is, can we have two individuals? One individual who takes part in entire mediation process and even receive confidential information, and other individual who only take part in the joint process but do not take part in the private process where confidential information is shared. So that this person who does not receive confidential information can act as an arbitrator in a fair and impartial manner. I hope this makes sense to everybody. You can ask a question. So arbitrator is called back only to enter a consent award or to serve as an arbitrator if the mediation fails. Then there is this mechanism called MEDALOA, mediation and last offer arbitration. In this, you start with a mediation, and if the mediation fail, both the parties will say what is their preferred solution. For example, the dispute is between workman and the employer. Workman says that my solution is my salary must be hiked by 20%. Employer might have a different solution to it. Employer might say, I do not want to increase your salary by 20%, but what I can give you health insurance and 5% salary hike. Now, both the parties will give their solution, and the arbitrator can decide only one solution out of these two. Arbitrator will decide by taking evidence, by receiving evidence, by examining both the parties, by hearing both the parties, which of these two solution is good and which must be imposed on the parties. Now, this is not what is usually happened in arbitration. Arbitrator can pass any award, what is claimed in the prayers, in the relief section of the pleadings of arbitration. But in MEDALOA, the discretion of arbitrator is reduced. Reduced to what? What each party proposes a solution. Out of these two solutions, choose one. This is MEDALOA. Then we have something called negotiation, mediation, arbitration. Most of the arbitration agreement you will see, they have an escalation clause. This is also called an escalation model of deciding a dispute. That if between two parties a dispute has arisen, first try to amicably settle the dispute between the parties themselves. And if the parties are not able to come to a conclusion, bring a third party called mediator. Even the decision, even the proceedings with the mediator are consensual and non-binding, and therefore it may not work. And once the mediation fails, you go to arbitration. In all these processes, negotiators are the parties themselves, mediator is a different person, arbitrator is a different person. But this is also one variety of hybrid ADR where an escalation model is followed. This is one of the most popular hybrid ADR mechanisms in India. In one case, constitutional validity, not constitutional validity, the legal validity of this clause was challenged before the Supreme Court of India, and the court said it is perfectly fine, there is nothing wrong in such kind of clause. Then we have hybrid ADR in the form of assisted negotiation and mediation. What is assisted negotiation? Now tell me how many of you have ordered food from Swiggy or Zomato? I believe most of you have done that, right? You order food online and then you are probably unsatisfied with the food. So if you are unsatisfied with the food, what do you do? Can anybody tell me? What do you do when you are unsatisfied with the food you order from Swiggy, Zomato, or any other platform for that matter? As I mentioned, there is no right or wrong answer. Do not hesitate. You complain to them, Preeti. Preeti, if you can turn on your mic and tell me, how do you complain? Or Piyush, how do you complain?
Sir, I can complain by moving an application before the consumer court.
What are you
That is
saying?
no deficiency in services.
What are you saying,
It's a
Piyush?
complaint on their
For
complaint
the
portal, customer care.
cold food, for the cold food, you are going to move to the consumer court? Yes, Vivek, what were you saying?
I'll I'll complain to their customer care
Complain on their
department.
website. We write it on the website
Even
or
on the
by like
app,
giving stars to them. Like food is like pathetic. Like for that I'll
even
give
on
only 1 star.
exactly, Preeti, exactly. So even on the app, you talk to a artificial intelligence software. A human being does not talk to you. They have a predetermined software wherein responses are predetermined. You open their software, chat with the artificial intelligence, and tell them what is your problem. They ask you to share the picture, and if it fits within their regime, your query is automatically resolved. This is what we call as assisted negotiation. This is a negotiation assisted by technology between you as a consumer and between Swiggy or Zomato as the service provider. But sometimes you are not satisfied with the solution of assisted negotiation. In the software, it may appear like that you do not have any remedy. Your food will not be replaced, your money will not be returned back. Then what do you do in these cases? In these cases, some platforms like eBay tells that now you can opt for mediation. So as far as negotiation are concerned, they are assisted negotiation by the technology, by a chatbot. If you have heard about chatbot, there is a chatbot which talks to you and which helps you in resolving your query. And if that fails, mediation is used. This is one of the most popular hybrid ADR mechanism used in solving or resolving e-consumer disputes. E-consumer disputes. Flipkart, Amazon, eBay, Alibaba, Swiggy, Zomato, even so many banks now they have their software. If you have seen your debit card or credit card, there are Rupee debit card, Visa debit credit card, or Mastercards. Even they have their dispute resolution mechanisms, online dispute resolution mechanisms, wherein some software is interacting with you, and if the interaction with the software fails, then a human being comes into picture. So this assisted negotiation mediation as hybrid ADR mechanisms are lying in the domain of ODR. Prior to that, all of them were ADR, but ODR is also ADR. They overlap in that sense. So this is hybrid ODR. Then automated negotiation. In automated negotiation, something like blind bidding happens. You negotiate via email. On email, you tell what do you want. Say you receive the cold food, I want my entire money back. So if it was 500 rupees, I want my 500 rupees back. The other party will say, no, I can't give you 500 rupees. What I can give you a voucher for the future. That if you make a purchase in the future, then you can use that voucher and purchase whatever you want to order worth 500 rupees. Now the software will tell whether both the parties are arriving near the settlement. I don't know what the other party has offered me. Other party does not know what I have offered to it. All the offers of respective parties are feeded in the software, and the software tells just both the parties, are you approaching settlement or are you distant from the settlement? This is called blind bidding. If by coincidence or by consistent bidding, when both the parties come closer to each other in the proximate area, then the mediation is successful. This is automated negotiation coupled with mediation. Blind bidding happens. Both the parties are not aware of what are the respective offer. They are feeded in the software, and the software only tells party, are you very far from settlement or are you nearer to the settlement? If you are nearer to the settlement, negotiation will be successful. If you are very far from the settlement, you can choose a mediator and get your dispute resolved. And then there is something called crowd justice. The word in the bracket is pronunciated as you judge. It's not ujuz. It is you judge. What happens in this? Obviously, there has to be an agreement between the parties to resolve the dispute in this way. One party will record its video about its grievance, will upload it on YouTube. And now every person in the world can vote on it, that whether what person is saying is right or wrong, whether the person should be remedied as he or she is requesting or not. Crowd justice, the crowd is determining, public is determining based on my video uploaded on YouTube, whether what I am asking for is legitimate or not. But what is required prior to this posting video and taking response of the crowd is agreement between both the parties, that should this be done or should this not be done. This is called crowd justice. This is another way of hybrid ADR mechanism. Any question in the entire list of hybrid ADR before I go into some specific examples? Yes. Kindly take a good look at it.
Mr. Chirag, I wanted to ask, this negotiation, arbitration, assisted negotiation, mediation, automated negotiation and mediation. These three are basically for software based. I mean, like the queries has been solved through the softwares only, or we have, or whether we have specific like place to go with these queries. You said na ki this queries has been solved by way of software only. We have to put the things through the software. I mean, like whatever sites they have.
See, as far as negotiation, mediation, arbitration is concerned, it does not involve any software. Negotiation as two people negotiate one on one. As far as assisted negotiation is concerned, automated negotiation is concerned, yes. For the negotiation, there is a software, artificial intelligence software. But if the
Yes.
artificial intelligence software is not able to give you solution, then mediation happens, wherein there will be a third party mediator like it happens. So mediation will involve a human being. Negotiation is through the software. I hope this answers your question, Preeti.
Yes, Mr. Chirag.
You can call me Chirag. Let's move to some key statistics about hybrid ADR. SIDRA is one organization. This is International Dispute Resolution Survey. They state the preference of the parties, of the commercial parties. The first most preferred ADR mechanism is international arbitration, which is 74% preferred. Then international litigation, court, and third most popular is hybrid mechanism, 27%. Mediation even doesn't appear in top three. So this is a survey before Singapore Convention on Mediation came, right? So probably after Singapore Convention on Mediation, mediation could be third. But currently, hybrid mechanisms come third in preference, which shows their importance. And even litigation is ahead of hybrid mechanism, which also is telling of whether parties internationally prefer mediation or not. Then why do parties prefer hybrid mechanism over standalone arbitration? So if the choice is between, on one side, should you use hybrid mechanism or should you choose standalone arbitration? Users have responded that what they want is that the business relationship must be preserved, 73%. Can anybody tell me how can arbitration affect business relationship? How can arbitration affect business relationship? Can anyone tell me? Yes. How can arbitration affect business relationship? Arbitration can affect business relationship because arbitration is adversarial. There are allegations and counter allegations like in litigation, and therefore it may affect the business relationship. So instead of arbitration, if you are using mediation and arbitration where parties are collaboratively resolving the dispute, it will preserve the relationship. Second is efficiency, something which I mentioned in the beginning of my presentation also, that what are the concerns with the arbitration? One of the major concern with the arbitration is efficiency, cost and speed. It takes lot of time, it is not efficient sometimes, and it is also very costly. This is what parties are also saying. So 47% of the parties feel that they prefer hybrid ADR over standalone arbitration because it is not efficient. Then what are the reasons for choosing hybrid mechanism over mediation? So it is hybrid mechanism versus mediation. Again, 53% believe efficiency, 53% believe cost is the factor, and then 48% enforceability, 45% speed, and 45% finality. These are some of the reasons why hybrid mechanism has been used instead of mediation. Efficiency, cost, enforceability, speed, finality. If you have any question, please let me know, else I'll move to my next point.
Sir,
Yes, Aditya?
Sir, can you please throw some light
no sir question.
on the issue?
What?
Am I audible?
Yes.
Can you throw some light as to how arbitration and hybrid ADR are more cost effective? Because whatever the experiences are, the arbitration fees and proceedings will definitely be equal to as good as with the arbitration and ADR. So how you are suggesting that hybrid ADR is much more cost effective?
This is not what I am suggesting. This is Sidra survey. A survey conducted with the users of arbitration and hybrid mechanism. They said that it is more cost effective. Now, what are the reasons why they said that?
Yes, that
Arbitration
is
is
what I
costly because it takes lot of time. So you are paying a lawyer on day-to-day basis, per date basis, per appearance basis. Longer the tenure you have engaged an arbitrator, cost increase. The longer the time you are using arbitration infrastructure, again cost increase. Whereas hybrid ADR, if during arbitration you are able to settle the dispute by mediation, obviously it is cost effective. So that's how hybrid mechanism could be cost effective than arbitration. I hope this answers your question,
Okay,
Vivek.
okay, Chirag. Thank you, Chirag. Thank you, Chirag.
Sure. So let's see this best practice, which is introduced by Singapore International Arbitration Center and Singapore International Mediation Center. Now, both of these centers collaborated and provided for what is called as ARB protocol. Now, how does this work? ARB protocol or AMA protocol, it allows a party to commence arbitration under the auspices of SIAC, Singapore International Arbitration Center, and then proceed to mediation under SIMC. In practice, how it will work? Parties will, as they do in regular arbitration, they will commence the proceeding, they will send notice to arbitrate to the registrar of Singapore International Arbitration Center. And once this notice of arbitration has been received by the registrar, he will notify this filing to the sister institute SIMC, Singapore International Mediation Center. After arbitral tribunal has been constituted, the tribunal will stay the proceedings and will ask SIMC to conduct the mediation. SIMC fix a date for the commencement of mediation and it will do the mediation as per SIMC mediation rules. Now, unless the registrar of Singapore International Arbitration Center and SIMC jointly agrees to extend the time within 8 weeks, that is within 2 weeks, mediation must get finished. It must get over from the date of commencement. This is AMA protocol or ARB-MED-ARB protocol. So this is an example of two international institutions in Singapore coming together and collaborating that we specialize in arbitration. So let the arbitration begin. But when it comes to mediation, we will not venture into mediation. We will refer the dispute to mediation center and let the mediation center help parties in arriving at the settlement. If it finds, then the settlement agreement will be passed as an award. If it fails, with all the documentation, refer the parties back to SIAC and SIAC will conduct its arbitration. Now, how to use it? You need to have a model arbitration clause in your contract. It is not that you can just do it out of blue. Parties need to express their consent to such AMA protocol, that they want to use AMA protocol, and in their contract, the clause which I have mentioned in my slide should be inserted, which goes like this. All disputes, controversies, or differences arising out of or in connection with this contract, including any questions regarding its existence, validity, or termination, shall be referred to and finally resolved by arbitration in Singapore in accordance with SIAC rules for the time being in force. The parties further agree that following the commencement of arbitration, they will attempt in good faith to resolve the dispute through mediation at the SIMC in accordance with SIAC SIMC ARB-MED-ARB protocol for the time being in force. Any settlement reached in the course of mediation shall be referred to arbitral tribunal appointed by SIAC and may be made a consent award on agreed terms. So settlement agreement will be passed as a consent award by the arbitral tribunal. So this gives force to the settlement agreement. Otherwise, settlement agreement is always, there are doubts about it, whether it will be enforced or not, whether it will be complied with by the parties or not. In this kind of case, because of the use of arbitration, because of the involvement of SIAC, which will pass the settlement agreement as a consent award, the settlement agreement becomes binding on both the parties. So this is how, if you want to use AMA protocol, you need to use this clause in your agreement. What are the examples of ARB-MED under law? Under Indian Arbitration Act, we have section 30, which talks about settlement. And it says that if an arbitrator sees an element of settlement, he can refer the parties to a mediation, or he can help parties in arriving at the settlement, whatsoever the parties mechanism they want to use. Similarly, in Singapore, they have section 16 and 17, which state an arbitrator may act as a conciliator if the parties consent to in writing. The same possibility also exists in Hong Kong, section 32 and 33 of the Arbitration Ordinance of Hong Kong. So these are three provisions of ARB-MED or ARB conciliation. Section 30, Section 16 and 17 of Singapore, and Section 32 and 33 of Arbitration Ordinance of Hong Kong, wherein in between arbitration, if there exists an element of settlement, matter may be referred to mediation or conciliation. Moving further, concilio arbitration or arbitration conciliation. This is an example I have taken from investor state arbitration agreement. An example is ASEAN Comprehensive Investment Agreement. It is a free trade treaty under international law. Article 30 of this free trade agreement, FTA, consists a hybrid dispute resolution mechanism, which states that disputing parties may at any time agree to conciliation, which may begin at any time and be terminated at the request of disputing investor at any time. So during the course of arbitration, disputing party may agree to conciliation. This is what Article 30 of ASEAN Investment Agreement states. Then look at UNCITRAL, United Nations Commission on International Trade-related Aspects of Law. It has technical notes on online dispute resolution of 2017, which prescribes a three-stage process. The first stage, as I showed in my earlier slide, a technology-enabled negotiation. Parties to dispute will attempt to negotiate directly to resolve this matter with the help of technology. Second stage is mediation, where facilitative model of mediation will be used and attempt will be at an amicable settlement. And third is commencement of ODR proceedings, essentially arbitration, online arbitration, where parties will be informed of the process by neutral third party appointed. So these are the three stages in the ODR UNCITRAL notes which recognize a hybrid process. The first stage is technology-enabled negotiation, second mediation, and third online arbitration. Let's move further. Now, when I say hybrid process and when I mention that hybrid process overcomes some of the challenges of arbitration and mediation, that does not mean that they themselves are free from any challenges. They have some shortcomings of their own. For example, voluntary participation and voluntary withdrawal. Voluntary participation and voluntary withdrawal is one of the primary features of the mediation. Parties agree to mediate because the process is voluntary, right? This is what a mediator also tells in the opening statement, that if at any point of time you wish to leave this room, you can leave this room and nothing will go against you. This tiny statement during the opening speech of the mediator is very important, is as it recognizes the voluntariness of the mediation process. But when you club mediation with arbitration, or when you club arbitration with mediation, this voluntariness goes. Because then you are not free to walk away. If the mediation fail, you have to compulsorily do arbitration, the award of which will be binding upon you. Right? So there is no voluntary participation or voluntary withdrawal. Even if the mediation fail, you have to submit yourself to the jurisdiction of an arbitrator. This is the first challenge or the shortcoming of the hybrid process. Second, there are concerns related to confidentiality, a gist of which I also gave in my introductory slide. When a same person acts as a mediator as well as an arbitrator, then this person becomes privy to many confidential informations, which is problematic. As a party, how can I confide in the mediator if I know that in future he will become an arbitrator? Whether my acceptance or my eagerness to settle the dispute will make arbitrator bias, that this person must have done some wrong, that is why he's so eager to settle. So all these are some of the concerns which arise when same person act as a mediator and same person act as an arbitrator. There is no confidentiality. Parties may not confide in such mediator, and third party neutral, this mediator or arbitrator, whatever role he plays, he may get biased. because you hear so many confidential information during the mediation, during the private session. AMA protocol, which I showed you some time back by SIAC and SIMC, attempts to address all these three challenges. It retains confidentiality because now there are two institutions involved. Furthermore, not just two institutions, there is a different set of mediator and there is a different person who is an arbitrator. The person is not same. And therefore, the chances of such person getting biased is also non-existent. Another problem is when we talk about arbitration, one of the ethics of an arbitrator is that an arbitrator cannot hear the other party or cannot interact with the one party in the absence of the other party. This is one of the ethical standards of an arbitrator, that you do not attend the social gatherings of one party or you do not talk to one party in absence of other. But when the same arbitrator acts as a mediator, then how do you reconcile this? Right? Because when you act as a mediator, you can talk to one party in the absence of other party. This is what happens in a private session or a private caucus. So there is an element of perceived biasness when the same neutral act as an arbitrator and mediator and hear the other party in the absence, or hear one party in the absence of the other party. This is again one of the important challenge of a hybrid process. And the last being pressure to settle rather than being imposed by the award. I might think that I must settle this dispute because if I do not settle it, an arbitrator will pass a binding award. So there is a constant sword hanging on my head that I must settle whether the deal is in my favor or it goes against me. I must settle because if I don't do it, this arbitrator come mediator will pass a binding award against me with which I have to live whether I like it or not. So these are some of the challenges of hybrid process you can take note of. So hybrid process in itself is not free from challenges. It has its own shortcomings which may be resolved. Now, none of these are unresolvable. Some people may claim that they are unresolvable, but they are not unresolvable, as I demonstrated by way of SIAC, SIMC, AMA protocol. So, what are the solution to challenges? Appoint overlapping neutrals. Overlapping neutral means you have, now this is not anything to do with AMA protocol. Overlapping neutral means to begin with, when you started mediation, there were two neutrals. But only one neutral take part in the joint session and only one neutral take part in the private session. One neutral who is not party to a private session will act as an arbitrator. So this will ensure that because he didn't attended the private session, he is not privy to the confidential information. This is the concept of overlapping neutral. So you have two neutrals, but one of them act as an arbitrator, and the one who will act as an arbitrator will not take part in the private process or the confidential meetings. He will only take part in the joint meetings or the joint sessions. So he would be aware of the matter, but he will not be aware of the precise emotions or the technical nitty-gritties of the party, so that this person can pass an award, a reasoned award, in a bias-free manner. Then there's this concept of plenary mediation arbitration. In this, you must do the mediation, but in mediation, caucus is not permitted. If the caucus is not permitted, how do you share the private information with the mediator? So you are not going to share the private information, right? And that's why if this person, same person acts as an arbitrator, he is not privy to the private information and can act as an arbitrator. And then one another option is med-R with optional withdrawal. We were stating in the previous slide that the participation is voluntary and withdrawal is voluntary. But in med-R, you cannot withdraw. But you can always enter into an agreement that even in med-R, if at any stage party feel that I do not want to continue the process, I can withdraw from it. This will give the freedom to the party, confidence to the party that yes, this is something I want to do. This will make the process party centric and a neutral process. So med-R with optional withdrawal is another solution to challenge. Apart, these three are apart from the AMA protocol and some other solutions which we can think of. So this is my presentation for the day. Thank you so much to the presenters, to the organizers for giving me this opportunity to interact with all of you. If you have any questions, you can please ask.
Hello.
Thank you,
Yes.
sir.
Yeah, Chirag, I'm Sagar Shrivas. I'm a student
Yes,
of PGDT. I have
okay.
one query. See, there's two things in arbitration and conciliation, and part three is conciliation. Part one is arbitration. In both the part, the non-reply of the notice leads to the non-acceptance of arbitrator. This has been written in the law. But
But what are
can
you saying? What is non-acceptance of arbitrator?
no reply of the notice, non-reply of the notice.
No, this is not the law.
If there is a notice,
Non-reply to the notice means ex parte proceedings can be conducted by arbitration, like it can
no,
happen in court.
there's one law in the arbitration and conciliation that if anyone does not give the acceptance or the consent of the arbitrator, then the arbitrator can be changed.
The question of changing an arbitrator is different from the question of appointing an arbitrator. If you're
Right,
talking about appointing an arbitrator,
right.
uh, if the arbitrator, you already provided a mechanism, say institution will appoint an arbitrator, then that institution can appoint an arbitrator. And if you fail to reply or object
Right.
to the appointment, such arbitrator will conduct the proceedings ex parte. If you want to change the arbitrator, it can also be done unilaterally, but you have to go to
Mhm.
the court. And if you want to do it by consent, both the parties can do it by consent. So
But
these
the
two are
thing is, I
distinct
want to
issues.
ask is, yeah, I want to ask is, can any commercial finance company issues this conciliation notice and deliberately pass the ex parte order and then goes to the court for enforce through arbitration?
They
See,
can do
both the
that.
things are different. Conciliation and arbitration are both the things are different. But a commercial finance company has done this.
This is happening rampantly in Mumbai also. I have myself acted as an arbitrator in some of these cases. So, first of all, property does not permit me to speak or comment on its legality. But nonetheless, from where I see, it is perfectly fine.
Okay. Thank you, Chirag.
Chirag, am I audible?
Yes, yes, you are audible.
One of my question is, according to you, except
Yes.
Arbitration and Conciliation Act, is there any statute prevalent in India which is adopting this hybrid mechanism of arbitration as of now? Or if yes, then what are those laws? If no, is there any bill pending before the parliament which is looking forward to adopt this hybrid mode of arbitration? That is statutory.
For hybrid ADR, you do not need a law. It is a party-centric process. What you need is party autonomy. So if parties think that they want to club two processes, they can do that by agreement. But if you still want a law, if you have read Industrial Disputes Act, now overruled by the Labor Code, Industrial Dispute Act had element of both arbitration and conciliation. It was statutory arbitration and statutory conciliation, and one step could happen after the other process. That's one instance of statutory hybrid ADR mechanism under the Labor Code, right? I also gave an example of the Commercial Codes Act where hybrid mechanism is provided. So at first stage, there's compulsory pre-litigation mediation and then litigation. But the problem is it's not ADR because it is litigation, but there is hybrid mechanism under Commercial Codes Act. So A, we do not need law. Second, you can find some instances where such ADR mechanism is provided, and third, at the end, it depends upon the parties what kind of process they want to follow, because party autonomy is the central principle of ADR processes and not the law. So anything is permitted unless prohibited by public policy or by the fundamental principles of the Indian law. Can we move to next question? Preeti, caucus means private session.
Thank you, sir, for explaining with simple examples the evolution of hybrid ADR mechanism. The session was very interesting and interactive. And if any one of you have any more questions, you can unmute yourself and ask, sir. So I would now request Dr. Vijay, Assistant Professor at Rashtrasan Tukloji Maharaj, Nagpur University's Postgraduate Teaching Department of Law, to kindly deliver the formal vote of thanks.
A very warm and a graceful good afternoon to all and the resource person. Rightly explained by Chirag sir that what the new concept of hybrid ADR and what are the challenges and how to overcome with it. And he has rightly explained and rightly give us the SIDRA survey where the hybrid ADR is a third most preferable one. And this is because this is very cost effective and efficient. And this will help, this helps in building the relationship, especially in the commercial world between the parties. So thank you, sir, for sharing your expertise in this contemporary issue or contemporary concept that is evolving, that is the hybrid ADR. And I also thanks the webinar team and the coordinator of this webinar, that is Padma Chaubey madam, and the technical team Abid Khan and Shikha Gupta and Bhumika. I also express my sincere gratitude to our head of the department for supporting us for conducting this webinar, and also thanks to all the participants for participating with a huge number. And thank you, sir. Thank you. Over to you, Bhumika.
Thank you, ma'am. Thank you all for being a wonderful audience and being patient participants to this session. I now request all the students to kindly fill in the feedback form link, which is shared with you in the chat box. And thank you all once again. Thank you.
Thank you, sir. Thank you so much. It is very informative and nice and very nice session, sir. Thank you.
Thank you, Chirag. Thank you so
Sharing
much.
your knowledge
Thank
and
you, Dr.
expertise.
Payal. Thank you, Padma ji. Thank you, Vijay. Thank you, everybody.
Thank you, sir.